where 751 federal judges found that an overwhelming majority.
The gentleman's time has expired.
Mr. Speaker, I yield myself such time as may consume.
The gentleman is recognized. Such time as may consume.
Thank you, Mr. Speaker. Federal judges found that an overwhelming majority of federal judges believed, based on their experience under both a weaker and stronger Rule 11, that a stronger Rule 11 did not impede development of the law 95%. The benefits of the rule outweighed any additional requirement of judicial time, 71.9%. The stronger version of Rule 11 had a positive effect on litigation in the federal courts, 81%. And the rule should be retained in its then current form. What we are attempting to reinstate into the law, 80.4% supported retaining the then current mandatory sanctions under the law. Mr. Speaker, this is about seeking real justice. And the fact of the matter is that just like a judge could not deny well-founded damages in a lawsuit brought by an individual under a valid legal claim of any other kind, they should not be able to have the discretion to deny any damages when a frivolous lawsuit is proven and the expenses of having to undertake the defense of that frivolous lawsuit are made, and yet time after time after time today, either people do not even bother to do it anymore because of the low record of granting damages in findings of frivolous lawsuits since it was made discretionary, and the mandatory provision should be reinstated into law, and I reserve the balance of my time.
The gentleman reserves. The gentleman from Michigan.
Thank you, Mr. Speaker. I'm pleased now to recognize a very effective member of the House Judiciary Committee, the gentleman from Florida, Ted Deutsch, for 2 minutes.
The gentleman is recognized for 2 minutes.
Thank you, Mr. Speaker, and I thank my good friend, Mr. Conyers. Mr. Speaker, the Lawsuit Abuse Reduction Act is, make no mistake, little more than a GOP effort to turn back the clock on civil rights, on consumer protection, and on justice in America. I urge my colleagues to vote against it. To most people, what this bill is sounds harmless. It reinstates the 1983 version of Rule 11 in our federal civil procedure. Indeed, the legislation is full of legal jargon and obscure technical language, but the American people still need to know why it is that the majority wants to go back to 1983 so badly. They want to reinstate the 1983 rule for the very reason it was taken away in the first place. It unfairly disadvantaged consumers, employees, and other ordinary Americans that tried to take on big corporations in our court system. The Lawsuit Abuse Reduction Act doesn't stop frivolous lawsuits. It only makes it easier for corporations to file frivolous lawsuits for the sole purpose of delaying the legal process and driving up the cost of litigation. These tactics aim to make the price of justice too expensive for ordinary Americans, especially in cases involving consumer and civil rights. You don't have to take my word for it. Studies have shown that civil rights and discrimination cases made up just 11.4% of the federal court docket, but 22% of the cases derailed by this rule. History has shown us that the 1983 version of Rule 11 will further disadvantage everyday people with legitimate claims against corporations with deep pockets. Mr. Speaker, the current rule was developed by a judicial panel and embraced by judges across the country. They are the ones who hear the cases. They are the ones who receive and consider the unique facts of each case. They are the ones who are in the position to make the decision whether the landmark civil rights and consumer rights cases of our time should go forward in our legal process, not the United States House of Representatives. I ask my colleagues, stand up for everyday Americans' access to justice. Vote no on this bad bill.
Gentleman's time has expired. Gentleman from Virginia.
Mr. Speaker, I continue to reserve the balance of my time.
The gentleman reserves. The gentleman from Michigan is recognized.
We are ready to close, Mr. Speaker. Is Mr. Goodlatte ready? Chairman Goodlatte, are you ready to close?
Mr. Speaker, I have only myself as the remaining speaker, so we would be prepared to close.
Thank you very much.
The gentleman from Michigan is recognized.
Mr. Speaker, I yield myself the balance of the time.
The gentleman is recognized for 1.5 minutes.
Ladies and gentlemen, as we see now, the Lawsuit Abuse Reduction Act will turn back the clock to a time when the federal rules of civil procedure discouraged civil rights cases and permitted satellite litigation to run wild. I want to point out in closing that this is now the second day this week that the House is considering legislation aimed at solving a non-existent problem that has little or no chance of seeing the light of day in the other body, and is solely aimed at limiting access to justice for victims of egregious harms. Just as I asked yesterday, who actually supports this legislation? And why are we putting their interests ahead of victims? And why are we engaged in this charade when there are real problems facing our nation that our constituents are still waiting for us to address? With just 13 legislative days left this year, we still haven't considered immigration reform. We haven't passed a budget. We haven't considered a single piece of legislation that will create jobs and put America back to work. So really, whose interest is this House concerned with today? I urge my colleagues, oppose this legislation. And Mr. Speaker, Madam Speaker, I yield back the balance of my time.
The gentleman from Michigan yields back his time. The gentleman from Virginia.
Thank you, Mr. Speaker. I yield myself the remainder of my time.
The gentleman is recognized for 8.5 minutes.
And I will not use all of that 8.5 minutes. Mr. Speaker, I'm pleased that my friend and colleague, the ranking member of the Judiciary Committee, Mr. Conyers, raised the important issue of civil rights. It is absolutely important, and I share his concern that individuals who believe that their civil rights have been infringed in any way have the opportunity to bring actions in federal court, as long as those actions are not frivolous or based upon fraud. In fact, looking back, during the time when we had mandatory sanctions from 1983 to 1993, the Federal Judicial Center, in its study, found that the imposition rate of sanctions in civil rights cases was not out of line with that in any other type of case. Now, we have not rested there. When the committee marked up this legislation, the gentleman from Virginia, Mr. Scott, offered a bipartisan amendment which was added to the bill at the very end. This bill, I said it was a one-page bill. I'm actually slightly mistaken. It's a 1 1/3 page bill. And the 1/3 page that was added reads this way: Rule of construction. Nothing in this act or an amendment made by this act shall be construed to bar or impede the assertion or development of new claims, defenses, or remedies under federal, state, or local laws, including civil rights laws, or under the Constitution of the United States. So this measure is carefully crafted to make sure that we are not harming people's rights to seek legitimate redress of grievances in our courts. What it is designed to do is to eliminate frivolous and fraudulent lawsuits. And from the evidence of the survey of federal judges who worked for 10 years under the rule that we would instate again with the passage of this legislation, the overwhelming majority of them said they would not change the rule. And it's unfortunate that a small committee chose to move forward to make that change notwithstanding. And I would add, too, that those who claim that this is not about the little guy are overlooking the fact that small businesses are affected by frivolous lawsuits all the time. And the National Federation of Independent Business, which bills itself as the voice of small business and which represents hundreds of thousands of small businesses all across America, endorses this legislation. In fact, they wrote to us and said 84% of National Federation of Independent Business members agree that attorneys should face mandatory sanctions if they bring forth a frivolous lawsuit. The NFIB urges you to support final passage of H.R. 2655 and will consider it an NFIB key vote in the 113th Congress. So in terms of the little guy, both the small business person and the individual, this legislation is designed to protect individuals against frivolous or fraudulent lawsuits. And as I pointed out in my dialogue with another member a little while ago, I don't believe anybody can come forward and give me any other example where a legal claim is validly brought in court and the victim is able to prove that wrong was perpetrated and prove that there are damages resulting from that wrong, and yet be denied those damages by the judge. I challenge anybody to come forward and show me that. So why, if you have a process that says, under Rule 11, which it did say at one time and would say again with the passage of this legislation, that you have a right to a process to show and establish that a lawsuit is frivolous, why, after you have done that, wouldn't it be mandatory that the process take one step further and assess the appropriate amount of damages that would be due and owing that victim of that abusive lawsuit that suffers in all the same ways that other people suffer when they're the victim of abusive actions of other kinds that result in actions being brought in court? So I urge my colleagues to support this legislation, and I yield back the balance of my time.
The gentleman from Virginia yields back. All time for debate has expired. Pursuant to House Resolution 403, the previous question is ordered on the bill. The question is on engrossment and third reading of the bill. Those in favor say aye. Those opposed, no. The ayes have it. Third reading.
A bill to amend Rule 11 of the Federal Rules of Civil Procedure to improve attorney accountability and for other purposes.
For what purpose does the gentleman from Georgia seek recognition?
I have a motion to recommit at the desk.
Is the gentleman opposed to the bill?
I'm opposed to H.R. 2655.
The gentleman qualifies. The clerk will report the motion.
Mr. Lewis of Georgia moves to recommit the bill H.R. 2655 to the Committee on the Judiciary with instructions to report the same back to the House forthwith with the following amendment. Add at the end of the bill the following. Section 3. Protecting civil rights and preventing discrimination. This Act and the amendments made by this Act shall not apply in the case of any action brought under 1. Civil rights laws, including any case alleging discrimination based on sex, race, age, or other forms of discrimination, or 2. The Constitution.
Pursuant to the rule, the gentleman from Georgia is recognized for 5 minutes in support of his motion.
Thank you, Mr. Speaker. Mr. Speaker, this is the final amendment to the bill. It will not kill the bill or send it back to committee. If adopted, the bill will immediately proceed to final passage as amended. My motion is similar to an amendment offered by my good friend, Ranking Member Conyers, during the committee markup. It simply excludes civil rights cases from this Act. My amendment makes it crystal clear that discrimination based on sex, race, age, or other forms of discrimination will not be subjected to lengthy, expensive sanction. People should have a right to seek redress or petition the courts to act for an individual to be able to take legal action based on discrimination because of age, race, color, gender, sexual orientation is not senseless. It is not frivolous or silly. They are exercising their sacred right to work to make our union stronger and better for generations to come. Mr. Speaker, I'm not sure that my friends and colleagues in this body fully understand the importance of my amendment. Civil rights lawsuits are unique because they push the judiciary to review, question, consider, and update our nation's commitment, our constitutional duty to respect the dignity and the worth of every human being. These cases inspire our judicial system to explore and develop new legal theories and standards. And there is no doubt that legislation like H.R. 2655 would have slowed down many historic legal successes of the 20th century. Civil rights landmarks like Brown versus Board of Education would have taken another 10 years. Rights to marriage or privacy could have been debated for who knows how long. Blacks and whites would not have been free to marry. Same-sex couples would not have been able to love each other. Decision guaranteeing freedom of the press and First Amendment protection could be ongoing. Civil rights legal progress would have been even slower if this act was the law of the land 60, 50, or even 20 years ago. A judicial system of thoughtful, deliberative, constant review make our history, our progress, our commitment to justice a model for nations around the world. This effort has been tried already. It does not work, and my amendment corrects the greatest injustice of this bill. I urge all of my colleagues to support my common sense changes to this serious flawed legislation. This amendment is the right thing to do, the fair thing to do. It is the just thing to do. Thank you, Mr. Speaker. I yield back the balance of my time.
The gentleman yields back. For what purpose does the gentleman from Virginia seek recognition?
Mr. Speaker, I seek time in opposition to the motion to recommit.
The gentleman is recognized for 5 minutes in opposition.
Thank you, Mr. Speaker. I rise in opposition to this motion because the base bill makes sanctions for filing frivolous lawsuits in federal court mandatory. Under Rule 11, a lawsuit is frivolous if it is presented for any improper purpose, such as to harass, cause unnecessary delay, or needlessly increase the cost of litigation. If it is not warranted by existing law, or if the factual contentions have no evidentiary support. In other words, a lawsuit will only be found frivolous if it has no basis in law or fact. As soon as a judge finds that any claim of any kind is founded in law or fact, then no claim for for damages because of a frivolous lawsuit would lie. Who here thinks that lawyers should be able to avoid any penalty when the lawsuit they file is found by a federal judge to have been simply filed to harass, to cause unnecessary delay, or to needlessly increase the cost of litigation? Or when the federal judge finds that the lawsuit is not warranted by existing law, or to have no evidentiary support? If you think lawyers should be able to get off scot-free when they file those sorts of frivolous lawsuits, vote for this motion to recommit. But if you agree with me that the victims of frivolous lawsuits are real victims and that they have to shell out thousands of dollars, endure sleepless nights, and spend time away from their family, work, and customers just to respond to frivolous pleadings, then you must oppose this motion to recommit. When Businessweek wrote an extensive article on what the most effective legal reforms would be, it stated what's needed are penalties that sting. As Businessweek recommended, give judges stronger tools to punish renegade lawyers. Before 1993, it was mandatory for judges to impose sanctions such as public censures, fines, or orders to pay for the other side's legal expenses on lawyers who filed frivolous lawsuits. Then, the Civil Rules Advisory Committee, an obscure branch of the courts, made penalties optional. This needs to be reversed by Congress. H.R. 2655, the Lawsuit Abuse Reduction Act, would do just that. Now, the specific language of the motion to recommit means that it literally immunizes from sanctions frivolous civil rights claims. That doesn't further civil rights, that sets it back, because the only claims that sanctions could be issued on would be claims for which there is no basis in law or fact. That does not advance the cause. But I would add that the language in the motion to recommit adds shall not apply in the case of any action brought under 1, civil rights laws, and 2, the Constitution. That second provision, the Constitution, means that the motion to recommit covers every single lawsuit brought in any United States court in the land, and any federal court. And so it goes well beyond what is the stated intent of the motion to recommit. A better way to look at this is to look at what the Federal Judicial Center found in their study when they looked at the imposition of the mandatory sanctions under Rule 11 that existed from 1983 to 1993, and they found that the imposition rate of sanctions in civil rights cases was not out of line with that in any other type of cases. But furthermore, when this bill was drafted for this Congress, a very narrowly drafted bill, just 1 1/4, 1 1/3 pages long, we added a rule of construction for specific protection for valid, legitimate civil rights lawsuits that are based in law or fact. And it says, the rule of construction, as I said earlier, nothing in this Act or an amendment made by this Act shall be construed to bar or impede the assertion or development of new claims, defenses, or remedies under federal, state, or local laws, including civil rights laws, or under the Constitution of the United States. That's the proper way to protect civil rights litigation. Meritorious civil rights litigation founded in law or in fact. And that indeed is what the legislation does, and that is why the House should reject the motion to recommit and pass the Lawsuit Abuse Reduction Act. I thank all of the members on both sides of the aisle for this vigorous debate, and I yield back the balance of my time.
The gentleman's time has expired. Without objection, the previous question is ordered on the motion to recommit. The question is now on the motion. Those in favor say aye. Aye. Those opposed, no. No. The noes have it.
Mr. Speaker, on that, I demand the yeas and nays.
The gentleman from Georgia, the yeas and nays are requested. Those favoring a vote by the yeas and nays will rise. A sufficient number having risen, the yeas and nays are ordered. Members will record their votes by electronic device. Pursuant to Clause 8 and Clause 9 of Rule 20, this 15-minute vote on the motion to recommit will be followed by 5-minute votes on passage of the bill, if ordered, and adoption of the motion to instruct on H.R. 3080. This is a 15-minute vote.
The House has had under consideration a bill that would require federal judges to sanction lawyers that have found to have filed frivolous lawsuits. A motion to recommit here proposed by Representative John Lewis, Democrat of Georgia. 15-minute vote on the House floor. We also expect them to take up a final passage vote and a passion on a vote on the instructing the conferees on the Water Resources Bill. This first vote, 15 minutes, 2 votes following will be 5-minute votes. Off the floor of the House today, in fact, at the White House, President Obama today saying he announced changes to the health care law, saying that insurance companies will have the option of continue offering the plans. Their plans would otherwise be canceled in 2014. We'll show you all of that news conference as much as we can in just a bit. Over in the Senate, meanwhile, they are back in. They continue work on their bill that expands the Food and Drug Administration's oversight of compounding pharmacy. You can follow the Senate on our companion network, C-SPAN 2. The House voting on the motion to recommit on a bill dealing with frivolous lawsuits. This is a 15-minute vote. The White House today announcing, President Obama announcing that people will be able to continue to have their insurance policies into 2014 as promised before the passage of the Affordable Care Act. He made those comments at the White House earlier today. His Chief of Staff, Dennis McDonough, has been on Capitol Hill meeting with members of the House and Senate and talking about the proposed changes. Meanwhile, a plan is coming up in the House tomorrow. Fred Upton, Republican of Michigan, sponsoring a bill that would allow people to continue with their policies into 2014. That will come up on the House floor tomorrow. Democrat Mary Landrieu in the Senate, meanwhile, has supported a similar effort, similar legislation. Moments ago, she came out to speak to reporters about her efforts and about what she had to say about the president's comments as well. Here's what Mary Landrieu had to say.
Thank you all for coming today. I wanted to make just a brief statement about the announcement that the President made earlier today regarding keeping the promise that we made to Americans that have individual health insurance plans that may not be comprehensive, may not be exactly what they need, but it's what they have. And I believe they should be able to keep it. The President's step in action this morning was welcomed. It is a first step towards making that possible. His guidance that he has given out, I hope, will be received with goodwill by our 50 states, insurance commissioners, etc. I'm going to continue to work with the leadership. I'm open to working with Democrats and Republicans if there is a legislative fix that's also necessary. It's very important to understand, all of you know, that this is a very important step for our country. If this were easy to do, it would have been done 100 years ago. Our nation, the greatest on the planet, has been struggling for decades as to come up with a way that middle-class families and average, hard-working Americans and the entrepreneurs that are in our country that we're so proud of, we have been struggling and struggling with a way to provide for them affordable health insurance that they can depend on when they're sick, not just when they're healthy. Insurance they can afford, insurance that they can plan on having. The Affordable Care Act does that. Do we have some things to fix? Absolutely. Is this one of them? Yes. So the President's guidance is a great step forward. I have a bill. There are other bills that have been filed. We're going to be working across the aisle, not to repeal the Affordable Care Act, not to defund the Affordable Care Act, not to undermine the Affordable Care Act, not to gut the Affordable Care Act, but to fix it. Anybody that wants to work with me or anybody else to fix it, I'll be willing. Now, let me say that these cancellation notices that went out, they went out to Louisiana, California, North Carolina, Arkansas, lots of places. Under the President's guidance, these letters now will have to explain to people that receive them, you know, what their policy did and what is available for them now on the exchange. And many people will find better options on the exchange, assuming we can get those exchanges up and running, assuming we can get the websites working. Many people will find a better option. But we told people that if they had these plans, they could keep it. Now, I want to end with this because I'll answer your questions. I do not want to lose sight of the promise of the Affordable Care Act, and I'm going to give to the press this letter that I received from my office. I'm not going to read the whole part of it. But this child, Emily, who's now 22 years old, and her mother, Susan, wrote me this letter to say, Senator Landrieu, I know you're struggling with the ACA. I want to tell you this is worth fighting for. She goes on to describe her daughter, who lost her hearing as a young child, struggled through, got great grades, ended up going to one of the toughest universities in the country, as she was partially, deaf, partially deaf. She then gets hit by a car. This is too much to believe, but it's true. Cooper Union, Manhattan, gets hit by a car, And had she not been at the age of 22 on the Affordable Care Act, she would have virtually no insurance today. So don't lose sight of the promise of this bill, even though we have to get it fixed. Dana, and then I'll get you. Dana, let me get you. Go ahead.
What the President is doing is encouraging insurance companies to give people back their plans. Your legislation would require it. So is he going far enough, and are you going to continue to push for legislation?
Well, as I said, the President's guidance was welcome and well received. We still may have to fashion some legislation, and we're going to continue to work in that regard.
What is the Democratic leadership saying to you?
You'll have to ask the Democratic leadership. They are encouraging us to fix this. I mean, the Democratic leadership understands, since we're the ones that helped build this bill, the leadership in our caucus, how important it is. So ask them. But I am continuing to fight very hard for this promise to be kept.
Between a legislative fix and the administrative fix, why would something from Congress be necessary?
I couldn't hear the last part of your question. Well, first of all, the President has come to the conclusion, and he said this morning, he doesn't have the authority to direct commissioners of insurance. So Congress could do that. There's an Upton bill in the House, as you know. There's a Landrieu bill. There's a Udall bill. There's several bills that are moving through Congress. Now, my view of the Upton bill and my view of every Republican bill that I've seen is that it doesn't go to fix the Affordable Care Act. It goes to gut it. So, you know, it should be understood in that regard. But there are bills like mine and others that really want to find a way to fix this and to keep the promise. It's an important promise that was made, that people could keep, individuals that had insurance, even though it's expensive, even though the deductibles were high, even though most of these plans didn't really cover, you know, much at all. But it was their plans, and if they want to keep it, they should be able to. And I'm very hopeful, if the Affordable Care Act works as it should, that within a year or less, they will be able to find even better options on the exchange. But we made a promise, and we need to keep it.
So many of your Democratic colleagues have come out of the caucus and said, White House, great, more needs to be done, we need legislation. You don't seem to be saying that. You said we may need legislation.
No, I said, no. You're not hearing correctly. Go get your ears. Yeah, good. Go get your ears. I said the President's announcement this morning was a great first step, and we will probably need legislation to make it stick. However, do not underestimate the power of a presidential directive, and don't underestimate the willingness of insurance commissioners around this country, Republican and Democrat, to make this right for people. I mean, there are people in this country, contrary to what we might think here in this Capitol, that really want this legislation to work because they know the promise that it has for people. So that's why I'm being, you know, strong but careful in how we approach this legislatively.
Are you expected to pick up any more co-sponsors for your bill?
We have 6 co-sponsors now, 5 co-sponsors now, and we're picking up support every day. Of course, there's an important vote in the House that's going to take place that'll, you know, send some sort of signals. But we're continuing to pick up support, and again, I think we took a step, the President took a step in the right direction.
Your bill sets a threshold indefinitely for folks who want to continue their plans, allow them to continue as long as they're meeting eligibility requirements and paying their premiums. There are other ideas that I think make 2 years credit.
He's asking about the length of the bill. What I'm going to respond is one of the important components of my bill, which the President spoke about this morning, was the importance of the notification that the insurance companies will have to make, telling people, unlike this letter that says your plan is canceled basically with no explanation. Based on the President's guidance this morning, any new cancellation letters that go out will have to explain why your policy doesn't meet the threshold and what is now available to you, but it also will say that even though that policy doesn't meet the new threshold, you can keep it. So my bill is a permanent solution. We're going to be working to see how that can be shaped to make it real, hold the promise, and support the Affordable Care Act. No, one more. Yours.
Senator Meitner, do you have any concerns about the possibility that Republicans will push amendments on this subject, on the defense bill or anything else coming up? I know that your home state colleague has his own push on Obamacare-related amendments, but are you worried about any of those that might come up?
The only thing that I'm keeping my eyes on is the 800,000 people in Louisiana that don't have health insurance, the small businesses, hundreds of thousands that do, but their premiums keep going up every year, and they keep getting dropped because we had an unsustainable, unaffordable health care system in this country, and fixing it so they can depend on it, we can build on it, and they can count on it. And so that's what I'm going to do. I mean, I can't control other amendments that come up from any other bills, but it's important to focus, in my view, of fixing the Affordable Care Act. When we see problems, this is a problem and it needs to be fixed. Thank you all so much.
Louisiana Democrat Mary Landrieu, just outside the U.S. Senate, speaking to reporters a short while ago about her legislative efforts on the Affordable Care Act and allowing people to keep their health insurance policies. This after the president earlier today announcing changes to the health care law to give insurance companies the option to keep offering consumer plans that would otherwise be canceled. The President's Chief of Staff, Dennis McDonough, is on Capitol Hill briefing members of the House and Senate. We also understand that here in the House later today, once legislative business is wrapped up, Republicans plan to speak in 1-minute speeches following legislative work about the Affordable Care Act and some of the comments made by President Obama earlier today. This is the first vote, by the way, in a 3-vote series. This is the motion to recommit on a bill dealing with frivolous lawsuits. The President addressed reporters at the White House earlier today. Was scheduled to be a short comments and wound up being nearly an hour of a news conference in the Brady Press briefing room. We'll show you what we can from the President as this 15-minute vote continues.
Everybody, hello. Good morning, everybody. Good afternoon. Today I want to update the American people on our efforts to implement and improve the Affordable Care Act, and I'll take a couple of your questions. But before I do, I just want to say a few words about the tragedy that's unfolded in the Philippines. Over the past few days, I think all of us have been shaken by the images of the devastation wrought by Typhoon Haiyan. It's a heartbreaking reminder of how fragile life is, and among the dead are several Americans. So our prayers are with the Filipino people and with Filipino Americans across our country who are anxious about their family and friends back home. One of our core principles is when friends are in trouble, America helps. As I told President Aquino earlier this week, the United States will continue to offer whatever assistance we can. Our military personnel and USAID team do this better than anybody in the world, and they've been already on the ground working tirelessly to deliver food, water, medicine, shelter, and to help with airlift. Today, the aircraft carrier USS George Washington and other ships arrived to help with search and rescue, as well as supplies, medical care, and logistical support. And more help is on the way. America's strength, of course, has always been more than just about what our government can do. It's also about what our citizens can do. It's about the big-heartedness of the American people when they see other folks in trouble. So today I would encourage everybody who wants to help to visit whitehouse.gov/typhoon. That's whitehouse.gov/typhoon, and that'll offer you links to organizations that are working on the ground in ways that you can support their efforts. Our friends in the Philippines will face a long, hard road ahead, but they'll continue to have a friend and partner in the United States of America. Now, switching gears, it has now been 6 weeks since the Affordable Care Act's new marketplaces opened for business. I think it's fair to say that the rollout has been rough so far, and I think everybody understands that I'm not happy about the fact that the rollout has been wrought with a whole range of problems that I've been deeply concerned about. But today I want to talk about what we know after these first few weeks and what we're doing to implement and improve the law. Yesterday, the White House announced that In the first month, more than 100,000 Americans successfully enrolled in new insurance plans. Is that as high a number as we'd like? Absolutely not. But it does mean that people want affordable health care. The problems of the website have prevented too many Americans from completing the enrollment process, and that's on us, not on them. But there's no question that there's real demand for quality, affordable health insurance. In the first month, nearly 1 million people successfully completed an application for themselves or their families. Those applications represent more than 1.5 million people. Of those 1.5 million people, 106,000 of them have successfully signed up to get covered. Another 396,000 have the ability to gain access to Medicaid under the Affordable Care Act. That's been less reported on, but it shouldn't be. You know, Americans who are having a difficult time, who are poor, many of them working, may have a disability. They're Americans like everybody else, and the fact that they are now able to get insurance is going to be critically important. Later today I'll be in Ohio, where Governor Kasich, a Republican, has expanded Medicaid under the Affordable Care Act, and as many as 275,000 Ohioans will ultimately be better off because of it. And if every governor followed suit, another 5.4 million Americans could gain access to health care next year. So, bottom line is, in just 1 month, despite all the problems that we've seen with the website, more than 500,000 Americans could know the security of health care by January 1st. Many of them for the first time in their lives. And that's life-changing. And it's significant. That still leaves about 1 million Americans who successfully made it through the website, now qualified to buy insurance, but haven't picked a plan yet. And there's no question that if the website were working as it's supposed to, that number would be much higher of people who've actually enrolled. So that's problem number one, making sure that the website works the way it's supposed to. It's gotten a lot better over the last few weeks than it was on the first day, but we're working 24/7 to get it working for the vast majority of Americans in a smooth, consistent way. The other problem that has received a lot of attention concerns Americans who've received letters from their insurers that they may be losing the plans they bought in the old individual market, often because they no longer meet the law's requirements to cover basic benefits like prescription drugs or doctor's visits. Now, as I indicated earlier, I completely get how upsetting this can be for a lot of Americans, particularly after assurances they heard from me that if they had a plan that they liked, they could keep it. And to those Americans, I hear you loud and clear. I said that I would do everything we can to fix this problem, and today I'm offering an idea that will help do it. Already, people who have plans that predate the Affordable Care Act can keep those plans if they haven't changed. That was already in the law. That's what's called a grandfather clause. It was included in the law. Today, we're going to extend that principle both to people whose plans have changed since the law took effect and to people who bought plans since the law took effect. So state insurance commissioners still have the power to decide what plans can and can't be sold in their states, but the bottom line is insurers can extend current plans that would otherwise be canceled into 2014, and Americans whose plans have been canceled can choose to re-enroll in the same kind of plan. We're also requiring insurers to extend current plans to inform their customers about two things. One, that what protections these renewed plans don't include. Number two, that the marketplace offers new options with better coverage and tax credits that might help you bring down the costs. So, if you received one of these letters, I'd encourage you to take a look at the marketplace. Even if the website isn't working as smoothly as it should be for everybody yet, the plan comparison tool that lets you browse costs for new plans near you is working just fine. Now, this fix won't solve every problem for every person, but it's going to help a lot of people. Doing more will require work with Congress. And I've said from the beginning, I'm willing to work with Democrats and Republicans to fix problems as they arise. This is an example of what I was talking about. We can always make this law work better. It is important to understand, though, that the old individual market was not working well. And it's important that we don't pretend that somehow that's a place worth going back to. Too often it works fine as long as you stay healthy. It doesn't work well when you're sick. So year after year, Americans were routinely exposed to financial ruin or denied coverage due to minor pre-existing conditions or dropped from coverage altogether, even if they paid their premiums on time. That's one of the reasons we pursued this reform in the first place. And that's why I will not accept proposals that are just another brazen attempt to undermine or repeal the overall law and drag us back into a broken system. We will continue to make the case, even to folks who choose to keep their own plans, that they should shop around in the new marketplace, because there's a good chance that they'll be able to buy better insurance at lower cost. So we're going to do everything we can to help the Americans who've received these cancellation notices. But I also want everybody to remember there are still 40 million Americans who don't have health insurance at all. I'm not going to walk away from 40 million people who have the chance to get health insurance for the first time, and I'm not going to walk away from something that has helped the cost of health care grow at its slowest rate in 50 years. So we're at the opening weeks of the project to build a better health care system for everybody, a system that will offer real financial security and peace of mind to millions of Americans. It is a complex process. There are all kinds of challenges. I'm sure there will be additional challenges that come up. And it's important that we're honest and straightforward in terms when we come up with a problem with these reforms and these laws, that we address them. But we've got to move forward on this. It took 100 years for us to even get to the point where we could start talking about and implementing a law to make sure everybody's got health insurance. And my pledge to the American people is that we're going to solve the problems that are there. We're going to get it right. And the Affordable Care Act is going to work for the American people. So with that, I'm going to take your questions, and I'm going to start with Julie Pace of AP.
Thank you, Mr. President. The combination of the website problems and the concerns over the policy cancellations has sparked a lot of worry within your own party. And polls also show that you're taking some hits with the public on both your overall job approval rating and also on factors like trust and honesty. Do you feel as though the flawed healthcare rollout has led to a breach in the public trust and confidence in government? And if so, how do you plan to resolve that?
There is no doubt that people are frustrated. We just came out of a shutdown and the possibility that for the first time in over 200 years we wouldn't pay our bills. And people breathed a sigh of relief when that finally got done, and the next thing they know is that the President's health care reform can't get the website to work, and that there's these other problems with respect to cancellation notices. And you know, I understand why folks are frustrated. I would be too, because sometimes, you know, people look at what's taking place in Washington and they say, not enough is getting done that helps me with my life. And, you know, regardless of what Congress does, ultimately I'm the President of the United States, and they expect me to do something about it. So in terms of how I intend to approach it, I'm just going to keep on working as hard as I can around the priorities that the American people care about. And I think it's legitimate for them to expect me to have to win back some credibility on this health care law in particular, and on a whole range of these issues in general. And, you know, that's on me. I mean, we fumbled the rollout on this health care law. There are a whole bunch of things about it that are working really well, which people didn't notice.
On this vote, the yeas are 197, the nays are 225, and the nays is not adopted. The question is on the passage of the bill. Those in favor will say aye. Those opposed will say no. The noes have it. Gentleman from Virginia.
I'm going to ask for a recorded vote.
A recorded vote is requested. Those favoring a recorded vote will rise. A sufficient number having risen, a recorded vote is ordered. Members will record their votes by electronic device. This is a 5-minute vote.
its final passage on a bill that would require federal judges to sanction lawyers found to have filed frivolous lawsuits. It's a 5-minute vote. We were showing you the President's comments from earlier today at the White House. Of course, you can see all of that online in our video library at cspan.org. We'll also show it to you tonight beginning at 8 p.m. Eastern here on C-SPAN. The President's Chief of Staff, Dennis McDonough, has been on Capitol Hill meeting with Democratic senators. He's set to meet with Democratic members of the House shortly, and they may, after that, speak to reporters. We will keep you posted. We're asking for your thoughts about the changes in the health care law. The President earlier today announcing changes to the law that would give insurance companies the option to keep offering consumer plans into 2014 that might otherwise be canceled. If you want to weigh into the discussion, facebook.com/cspan is how you do that. Jerry says, so he's delaying the pain for a year to get through the midterms. Predictable. Michael says, but a month ago it was, quote, the law of the land and couldn't be changed. Now he can change it with a press conference, is his question. Again, some of the postings, the many postings at facebook.com/cspan.
On this vote, the yeas are 228 and the nays are 195. The bill is passed. Without objection, the motion to reconsider is laid on the table. The unfinished business is the vote on adoption of the motion to instruct on H.R. 3080, on which the yeas and nays were ordered. The clerk will report the title of the bill.
H.R. 3080, an act to provide for improvements to the rivers and harbors of the United States, to provide for the conservation and development of water and related resources, and for other purposes.